Hello everyone, and welcome to today's presentation providing an overview of legal ethics along with some of the most common violations we see. My name is Jerry Connor. I'm a partner in a law firm called Margolis Edelstein, and I practice primarily insurance defense law in the state of Pennsylvania. Today's program, however, will not be state specific and will really focus on the model rules of professional conduct, upon which really every state and jurisdiction's rules of professional conduct, rules of ethics, whatever your state calls them, chances are they share an awful lot in common with the model rules and are perhaps taken verbatim from the model rules. Now, if you look at the material, certainly we always put a disclaimer out there. This is general knowledge, general information based on the model rules, and everything we talk about may or may not be exactly the same as the rules you need to follow to maintain your professional licensing. However, across the country, certainly the basic rules of professional conduct apply, and all of the same theories and goals that are put out in the model rules that have made their way down to each state's exact codified rules are really very similar. So we'll talk about some of the very broad principles that are in place, and they'll apply really no matter where you are. But of course, always review your own rules in whatever state or jurisdiction you're licensed to make sure you're keeping everything professional and make sure you're maintaining your license and your clients in the way you should. Now, where do the model rules come from? They were adopted by the American Bar Association in 1983, and as I mentioned, they serve as the model for the ethics rules for just about every jurisdiction. They're based on a model code of professional responsibility from back in 1969, and before that, you have to go back to the canons of professional ethics that started in 1908. So these theories are certainly not new, and some of the basic ground rules for being a competent and professional attorney certainly predate even 1908. This is a great refresher for any of us to spend an hour looking at some of the big issues we need to address, just to always kind of keep ourselves focused on the ground rules that are really going to help us take good care of our clients, be good attorneys to other attorneys, to the courts, and certainly to our clients first and foremost. The model rules are not truly binding, but again, they provide a very good foundation upon which really almost every state has adopted something based, at least in part, on the model rules. In these discussions, what I always like to highlight first and foremost are the two options in the rules. The rules certainly are almost always a shall, a forceful statement that really needs to be taken at face value. These are the things you need to do, you must do, you shall do. We'll see as we go through some of the top rules of conduct, some of them are a may. You don't have to do certain of the duties or obligations that are set forth there, but you may. Those are few and far between, so we'll do our best today to try to highlight where you have any discretion at all in how you move your cases forward and how you conduct yourself, both with the courts and with your clients. But as we read through, most of these are mandatory. There is no discretion whatsoever. They're a shall, and we'll do our very best to highlight that as we go forward. Well, where do the rules start? Well, as you would expect, 1.1, competence. Literally, the very first rule that we deal with sets forth a very simple statement that has an awful lot of power packed into it. A lawyer shall provide competent representation to a client. Simple enough. Be competent. And you shall provide that. It's not you. If you want or you don't want, you must. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Now, of course, these model rules were written by lawyers and law professors. We have a layer of reasonably necessary for the representation. Not a whole lot of ground game in the case law and the ethics opinions on what's reasonably necessary, but you really need to know what you're doing before you choose any client or decide to accept any case. But you need to be competent.